or stop dialysis, even if any of that means you are going to die, you still have that right. And the doctor must either comply or refer you to a different doctor who will stop the treatments. But the problem is, what if you're unable to communicate? If a patient can't communicate, most doctors will err on the side of keeping them alive. Even if a friend or family member knows exactly what treatments you would or would not want, they do not have the legal right in all circumstances to make medical decisions on your behalf. And that's where advanced care planning comes in. It gives you the paperwork that will protect your right to have your health care wishes respected if you lose the ability to communicate. With the right kind of advanced care planning, the patient's wishes will be known and the chances of their being followed will be greatly increased. Absolutely everyone over the age of 18 should have a healthcare proxy. So that is the first thing that I will discuss. If you are suddenly injured or you become ill and you are unable to communicate, someone else will have to make healthcare decisions for you. If you have not filled out a healthcare proxy form, there is a very good chance that your healthcare wishes will not be honored. There is a law in New York called the Family Healthcare Decisions Act. It's a relatively recent law. It was passed in 2010. If you don't have a healthcare proxy, it designates the person who has the right to make decisions on your behalf. A spouse outranks an adult child outranks a parent outranks a brother or sister, and a brother or sister outranks a friend. The problem is that the person it designates as the one who can make decisions on your behalf may not be the person you can trust to follow your wishes. For example, maybe you know that your spouse would never be able to tell a doctor to let you go, no matter how strongly you have told them that is your wish. Or maybe you don't have a spouse, so a child, parent, or sibling will be the one with the authority to decide. What if you have more than one child or more than one sibling and they disagree with each other? Then you're back to square one and you don't have a real decision maker. For these reasons, it's much better to have a healthcare proxy than to assume that the Family Healthcare Decisions Act will result in what's best for you. Fortunately, the healthcare proxy form is very easy to fill out. No lawyer is required. It doesn't even have to be notarized. It just has to be witnessed by two people over the age of 18 who are not the healthcare agent or an alternate agent that you have designated. The form is only 2 pages long and very little needs to be filled in. You're seeing on your screen right now page 1, and this is page 2. That's it. You can see that this is a very simple form. When you fill out a healthcare proxy, you name someone you trust to be your healthcare agent. If you are unable to speak for yourself, that person will make your healthcare decisions for you, telling the doctor what kinds of treatment you would want or not want. The doctor is legally required to follow the instructions of your healthcare agent. You can name a spouse as your healthcare agent, or a child, or a friend, or someone else. But whoever you name, that is who the doctor must obey. No one else, regardless of their relationship to you. Since the person will have the power to make your healthcare decisions, the most important thing is that it be someone you trust to follow your instructions. It should not necessarily be a person you are very close to. Sometimes a spouse or child will be reluctant to stop treatments, even if you told them you didn't want them, because they don't want to feel they caused your death by stopping the treatment. It's up to you to decide who is most likely to do exactly what you ask them to do. There are two lines of thought about the best way to specify your wishes, and it's really a matter of personal preference which route you want to go. The first way is just to state your general wishes without getting specific. For example, you might write on the form, if there's no hope of recovery and I am suffering, I do not want to be kept alive by machines. Or you might say, I want everything possible done to keep me alive. Then you trust your healthcare agent to make the specific decisions that arise in the course of your treatment. It can be difficult to predict exactly what circumstances you will be in if you are ill. So many professionals advise their clients to keep things simple and let their healthcare agent use their best judgment. However, some people do want to get specific about what kinds of treatment they do or do not want, such as feeding tubes, ventilators, or antibiotics. And these can be listed on the healthcare proxy form or on a separate page that you staple to it. You may have heard of a living will. A living will is a document, often created with the assistance of a lawyer, in which you list the types of treatments you would or would not want under various circumstances. Unfortunately, a living will can be very hard to enforce in New York State. A doctor is legally required to do what your healthcare agent asks them to do. But if there is not a healthcare agent, a doctor might not follow the wishes that you expressed in your living will. Some doctors feel that the patient may not have really understood the nature of the treatment, or that they might have changed their mind when they were in the specific circumstance. And some living wills are so complicated that a doctor may feel unable to make sense out of it. So in New York State, there is currently no way to make sure that the wishes expressed in a living will are going to be followed if that is the only type of advanced care document the patient has. The living will can be stapled to the healthcare proxy form to specify your wishes, but a living will without a healthcare proxy does not fully protect you. You should give a copy of your completed healthcare proxy form or your living will to your healthcare agent so they can prove they are your agent. It's also important to give copies to family members and doctors. Do not just put it in your safe deposit box or a file on your desk, because if you're unable to communicate, it might not be found in time to be used. You've probably also heard of a do not resuscitate order, or DNR. A DNR instructs medical personnel not to revive you if your heart stops beating or you stop breathing. It only covers those circumstances, not other situations. The form you see on your screen right now is an out-of-hospital do not resuscitate order. That's what it looks like if you're not in the hospital. If you're in the hospital, some hospitals have their own forms. In some cases, the doctor just writes in your chart whether you're a DNR or not. For most elderly people, CPR usually causes more harm than good and is unlikely to return a person to a good quality of life. So many elderly people choose to have a DNR. If you're young and healthy, CPR has a very good chance of saving your life, so it's definitely worth it. But if you're elderly and frail, you have a very low chance of surviving. And if you do survive, you may have brain damage that stops you from returning to the life that you had before the incident. A DNR order must be signed by a doctor. It's only good if it's signed by a doctor. It should also be easily located. If EMTs come to your home and they do not see a DNR, they will resuscitate you no matter what your family members tell them. If someone has a DNR and wants to increase the chances that it will be followed, they should post it on the inside wall next to their front door so that if EMTs enter, they will see it. There is another relatively new document in New York called MOLST, meaning Medical Orders for Life-Sustaining Treatment. The MOLST form was created in 2008. Most people are unaware of its existence. Even some doctors and elder care lawyers have not heard of it. The MOLST form must be signed by both the patient and the doctor. Or if you don't have decision-making capacity, it can be signed by your healthcare agent and the doctor. Because it is signed by a doctor, it is much more likely to be honored than a living will is. Because unlike a living will, a MOLST form is considered an official medical order. Not all doctors are willing to sign a MOLST, and some that are willing might only sign it if you are likely to die within a year or if you are in a nursing home. However, there's no law that requires that that be the case. So if you don't know anyone that you could appoint to be your healthcare agent, it's worth trying to ask a doctor to sign a MOLST form for you, even if you're not elderly and even if you're not ill. Some doctors might be willing to do that. And like I said, the MOLST form will have a much greater chance than a living will of being honored in the absence of a healthcare agent. So I'd now like to take your questions. If you can write them in the box that's provided to write questions in. I believe I can see this box. It appears I can see it. But if I'm not seeing your questions, Shayna can read them to me.
Yeah.
Shayna, are you there?
Yeah, I'm here.
Okay, good.
Okay, right. Can you see the chat one?
I can. I see the chat box. I don't see any questions at this point.
Click on it.
Click on the box.
Yeah, it's on the box.
I see a box that says Q&A and it says no open questions. Do I need to stop my share?
It's okay. That's okay. You can leave your chair. Just click on the chat where it says one. On the bottom.
Yeah, oh, here it goes. Okay, I'm seeing the questions. First question, where should you keep the MOLST form? Well, just like a healthcare proxy, you should give it to anybody who you think might be involved if you became ill and unable to communicate. So if there are close friends, family members, they should have it. If you have doctors who are other than the doctor who signed the MOLST form, it would be good for them to have copies. And it would be good if you enter the hospital to bring a copy with you if you are conscious when you enter the hospital. Next question, the MOLST form. Is it international? The MOLST form is only good in New York State, technically. Each state, well, actually, some states don't have MOLST forms at all. Some states have something very similar to the MOLST form, but they call it a POLST form. And the forms are different in every state. So technically, you can't be sure a MOLST form will be honored in another state or internationally. But it is possible that they might honor it. So it is a good idea to take it with you if you travel. And if you spend a lot of time in another state, for example, if you go to Florida every winter, then you should try to fill out a form in that state that is honored in that state. And I see the questioner lives in Canada, so this applies. You may want to check in Canada to see if they have their own version of the MOLST form there. The next question just says healthcare agent ? So I'm not sure what that question.
Maybe they met what is a healthcare agent?
Say that again.
Maybe they met what is a healthcare agent? Maybe that's.
Oh, I'm sorry. Yes, I was using. You can use the healthcare agent. That's an excellent question. The healthcare agent is the person who you named in your healthcare proxy. That's the correct terminology. The healthcare proxy is the form, and the healthcare agent is the person you named. However, nowadays, most people are using healthcare proxy, whether they mean the form or the person they named. So it gets confusing. So really, you could either say healthcare proxy or healthcare agent. It means the same thing, the person who you named. Okay, the next question I see says, you indicated that the organization engages in advocacy. What is going on now to get a New York state law to make it legal for doctors to help people die who decide their quality of life is not adequate for them to want to continue living? How can people get involved in advocacy for a New York state law about medically assisted suicide? Okay, right now, there is a law that has been proposed to the New York State legislature called the Medical Aid in Dying Act. Medical aid in dying, which is the procedure that you indicate here, it allows a person to get a prescription from a doctor to end their life if they are terminally ill and mentally competent. It's legal now in the same way in 7 other states in the United States and the District of Columbia, and it's also legal in all of Canada. So we're trying to get it legalized here in New York, and it's very important, if you're in favor of this law, to write to your assembly member or state senator within the New York State Senate and tell them you want this law passed. On our website at endoflifechoicesny.org, you can access a system where even if you don't know who your assembly member is or who your senator is, it will automatically send a letter to those people based on your address. So you can do that on your website. But if you have any questions about aid in dying, how you can advocate for it, then after this webinar, please email me at Laurie@endoflifechoicesny.org. Laurie is spelled Laurie at endoflifechoicesny.org. Or you can call us at 212-726-2010. Okay, next question. Thank you for this great info. Will there be a replay of this seminar or can you email the presentation slides and forms? Shayna, will there be a replay of this seminar?
Yes, we can reschedule another one. I think it will be by March or April.
Okay, good. And also, if you do want the presentation slides, you can email me. Again, the address is Laurie, Laurie, at endoflifechoicesny.org. Or you can call the number 212-726-2010. The forms are available on our website. You can download them there. Next question. Can we give the most form to the healthcare agent? Yes, you can certainly do that. You certainly should do that so that the healthcare agent knows that the wishes are, knows what the wishes are that you indicated in the most form. By the way, at one earlier point, I said that you could staple your living will to your healthcare proxy form. You could also do this with your most form, but you don't have to. You can just give those forms to your healthcare agent. They don't necessarily have to be stapled to the form. And some people feel that it's actually better not to staple them to the form because it's better for them just to be brought up by the agent as things arise. But what's very important is your healthcare agent has to know your wishes. So don't just give them a copy of your healthcare proxy form. Make sure they also know what your wishes are. That is all the questions I see at this time, unless you have any others, Shayna, that were sent to you.
No, oh yes, we did have one online since yesterday. I can read it for you. Okay, the person says, I do not have anyone willing to take on the role of medical proxy. I have a complex medical history, including 2 blood cancer and remission, and I am 81 years old. If there's a way to split the responsibility so that one person can make the medical decision and the other can make arrangement for rehab or nursing home, should that become necessary?
Did you say, is it necessary? Is it okay for one person to decide about the nursing home and one person to decide about the medical?
Yes.
Yes, that is fine. And the other thing is, given the situation that you described, you should have no problem getting a most form from your doctor. So I would definitely do that as soon as possible, because you can indicate on the most form a number of your preferences, and it is the easiest document to get enforced.
Okay.
I see a couple more questions came in. Here's a question. My coworker viewed this webinar with me, but did not have a chance to register on time. Would she be able to get credit for this webinar? I'm not sure what that means in terms of getting credit. Do you understand, Shayna?
Me too. I'm not sure. I don't know if people were registering to get credit, but we can schedule another one. But I'm not sure about the credit.
We do offer workshops for social workers that offer continuing education units, but that's not in the form of this webinar. That's a 2-hour workshop. But that's the only thing that we as an organization offer credits for. Next question. Could you explain the purpose of the most? Both my doctor and attorney seem very resistant to using it. Well, that's unfortunate that they're resistant. I would be very curious as to why they're resistant. So in some cases, it's just that it's so new that doctors and attorneys are nervous about it because they've never seen it before. and they don't know whether they fully understand it. So personally, if I wanted a most form and my doctor was resistant to using it and didn't seem to have a good reason, then I would look for another doctor to fill it out. But the purpose of the most form is to make your wishes clear and to get them enforced. And like I said, because it's signed by a doctor, it's like a prescription. Other doctors are more willing to honor it because it's a medical order. It's an official medical order. Next question. Oh, I see. It's explanation that the credits were for DFTA training credits. And yeah, I don't know anything about that.
So we didn't have it for the DIFTA training credit. So we can, because the training is only an hour. And I know for the one that's for credit, it's 2 hours, right, Laurie?
The one for, yes, but ours only applies to social workers, not to DFTA credits.
Yes, but I guess the DIFTA person that will be registering, they will be a social worker. That's what I'm thinking. But because this training is only an hour, so there's no credit for the next one. We can definitely make it longer, and if people are interested to get the credit for it.
And if people know any social workers who might be interested, the workshop is what social workers need to know about end-of-life care, and please, pass on to them the suggestion that they contact us.
Yes. There's another question.
I see. Some clients are resistant to obtaining a power of attorney, DNR, or healthcare proxy, as they say, someone knows my wishes and I don't have any money. How can I stress the importance of having advanced directives in place without pressuring the client? Well, none of this costs any money. In the case of a MOLST form or a DNR, you'd have to go to the doctor. And if you didn't have insurance or Medicare, I suppose that might cost money. But you don't need an attorney for any of these forms. So there really is no cost. The healthcare proxy forms are free of charge. You can download them online or call the Department of Health and get them that way. So, and like I said, it doesn't even have to be notarized. So there is no cost to obtaining a healthcare proxy. And like I said, if someone knows your wishes, you're only safe if they fit those criteria on the Family Health Care Decisions Act. So if your spouse knows your wishes, if you have a spouse, and if they know your wishes and they're alive and you trust them to do what you ask them to do, then you're covered even if you don't have a healthcare proxy. But if you don't have the right person according to the law eligible, then you need a healthcare proxy to be covered.
This is a really good question because I believe that a lot of time people are misguided when it comes to the POA or the DNR. They really thinking it's about money, but it's more about what they want. If they're in the hospital, I think it's like that. Just telling them is not really about what they want to do with their money. It's more about your health. Maybe help a little bit, but I come up to a lot of clients that they don't know the difference between these terms, these terms.
Right. So I don't see any other questions.
Yeah, that was really a really good presentation, Laurie.
Thank you.
Information. And I see a lot of people are interested if you definitely we just have to schedule. And then for the credit, so that they can email you. Can you put a slide where you have your information so everybody can see it?
I'm sorry. Oh, Yeah, I should have made a slide with my information, but I don't. I have a slide about end of life choices New York, but I have no contact information there. But if you, I know website addresses are complicated to give. If you just Google end of life choices New York, it will take you to our website and there's contact information there.
Okay. And then their number, your direct number, direct number.
Sorry?
Okay, can you say your number again?
Yes, the telephone number is 212-726-2010.
Okay, that's great. Thank you, everybody. If anybody has any other question, they can directly to email Laurie or go to their website. We please to join the webinar. We just have to schedule it. And thank you again, Laurie, for doing it. That was really really
Thank you.
no problem. Thank you, everybody. Have a good rest of your day.